Article 1 of the convention states that the convention can be invoked for civil or commercial matters. It also says that the convention should be used for judicial proceedings. The big question is this: can it be invoked for arbitration? Would that fall under the term judicial proceedings? And if it can't, can parties to an arbitration apply to the court at the seat, assuming that it's a state party of the convention, to make a request for them? And does that convert the situation into judicial proceedings? So the best person, I think, who should start the discussion is the judge on the panel. And if I could invite Justice Reyes to answer.
Thank you very much. The second paragraph of Article 1 says, a letter of request shall not be used to obtain evidence which is not intended for use in judicial proceedings, commenced or contemplated. So the Chapter 1 procedure is not available for arbitration, as it's only intended for judicial proceedings. I don't think arbitration can be classified as judicial proceedings. Is there any point to using Chapter 2 proceedings for arbitration? I don't think so. Arbitration is largely a matter of party autonomy. The parties agree. A witness in some jurisdiction, whether or not a party to the convention, agrees to give evidence voluntarily. In that case, there's nothing to stop a witness from giving evidence in an arbitration over video to an arbitration taking place somewhere else in a different seat. This is purely a matter of voluntary arrangement between parties. There's no reason why a state should regard this as an interference with the state's national sovereignty. So I don't think there's any need for the convention in relation to international commercial arbitration.
Perhaps I could ask João to respond to that. Do you agree, disagree, want to add on?
Well, I'm in this very comfortable position that I personally cannot agree or disagree, but what I can add is that this has been discussed in previous special commissions, and indeed, it may be possible to seek assistance from a judicial authority in a state for the issuance of a letter of request. Scholarship has argued against it, but there are cases being reported where courts have assisted arbitral proceedings. And the stronger case may be made when referring to jurisdictions that have enacted the 2006 model law and Article 27 that says that the arbitral tribunal or a party with the approval of the tribunal may request for assistance in taking of evidence. But this is clearly an open question, but I must point out that there are several states reporting that the convention can be used to assist the arbitration proceedings, from Switzerland to the US, several jurisdictions in Scandinavia, Baltic states, also in the region, by the way. Macau SAR and Hong Kong SAR have reported cases where the convention has been used to assist arbitration proceedings. It's definitely a question that requires further discussion, and the special commission coming in the first half of 2023 will hopefully provide further contributions to a unified interpretation on this matter.
Thank you, gentlemen. By the way, it doesn't mean that if I direct a question to any particular person, only that person can answer. If anybody wants to chime in, please do. So would anybody else like to chime in on that controversial first question?
So thank you, Ed. I would just chime in from the French point of view to say that it really depends on what the tools available are in each country. So in France, for example, there are what they call expertise proceedings, Article 145 proceedings, which can be where you can go to a court, have an independent expert appointed to take discovery, obtain discovery, and then use that discovery in connection with arbitration proceedings, both domestic proceedings and international proceedings. Similarly, under the Federal Arbitration Act in the United States, there are ways for a tribunal that agrees that there should be discovery taken to seek the assistance of a local U.S. court in order to get evidence from an unwilling local witness. And that's really the problem. As the Justice said, arbitration is contractual. when everyone is willing, it works absolutely wonderfully, but it doesn't always work well with unwilling witnesses, and occasionally the parties and the tribunals need to find ways to compel discovery.
So you've heard now various ways where you might be able to argue in favor or against it, and I think it's good to leave it. Oh, sorry, João.
Yes, I just want to add one point that I'm being reminded that it's very important. You know, the Hague Conventions, the HCCH Conventions have a specificity. Their operation is reviewed through special commissions where contracting parties come together and discuss these matters. And the last special commission actually endorsed that the convention can be used to support arbitration proceedings if, of course, the domestic law allows for it. So there is some support or significant support for the convention to be used in arbitration proceedings.